Question 1. What is business law? Answer. Commercial law, also known as business law or corporate law, is the body of law that applies to the rights, relations, and conduct of persons and businesses engaged in commerce, merchandising, trade, and sales. It is often considered to be a branch of civil law and deals with issues of both private law and public law. Question 2. What is a legal contract in business? Answer. A contract is an agreement between two or more parties to perform a service, provide a product, or commit to an act, and is enforceable by law. There are several types of contract, and each have specific terms and conditions. Business 103. Introductory Business Law. Business courses. Question 3. What can you do with a degree in business law? Answer. Essential information. A business lawyer is an attorney who specializes in working on business law or transaction issues. These lawyers need Juris Doctor, JD, degrees and may have additional postgraduate degrees in business law. Like all lawyers, business lawyers must pass their state's bar exam to become licensed. Question 4. What is the meaning of mercantile law? Answer. Mercantile law, that broad area of the law, also called commercial law, statute, cases and customs which deal with trade, sales, buying, selling, transportation, contracts and all forms of business transactions. Question 5. Which type of statute prohibits an activity that used to be permitted or permits an activity that used to be prohibited? Answer. Passive legislation either prohibits an activity that was formerly permitted or permits an activity that was formerly prohibited. Active legislation gives government the right to carry on various programs, which in turn gives rise to the need for subordinate legislation created by administrative agencies to exercise their regulatory powers. A bill is a proposed law that has not yet received royal assent. Question 6. In Ontario, the Small Claims Court hears. Answer. In Ontario, the Small Claims Court hears civil claims up to $25,000. Less serious criminal offences are heard by the Ontario Court of Justice. Ontario's Trial Court, the Divisional Court of the Superior Court of Justice, hears appeals of civil cases up to $50,000. Taxation disputes are heard by the Tax Court of Canada. Question 7. State what is not true about evidence at a civil litigation trial. Answer. Ordinary witnesses may testify only about facts they know firsthand, while experts may provide opinions based on the evidence. The courts do not normally listen to hearsay evidence, information a witness heard from another person. Question 8. What is not true about a tort as distinguished from a crime? Answer. The usual remedy in tort is compensatory damages, whereas punishment is the usual remedy for a crime. For a crime, the relevant law is public law, under which the accused owes a duty of care to society and is prosecuted by the government. Question 9. Using fault or blameworthy conduct to assess liability under tort law. Answer. Circumstances can often make it hard to establish who was at fault, and it would be unfair to leave a victim uncompensated just because of this. Thus, while fault is one consideration in assigning liability, it is not the only basis. Fault is a less onerous standard than strict liability. Basing liability on fault would make people more careful since they would have to pay the consequences for being careless, but that would be a desirable result. Question 10. The defense of qualified privilege in a defamation case means that. Answer. Qualified privilege occurs when the statement was made in the course of duty with the belief that it was true, and was communicated only to those who needed to know. A is the defense of justification, B the defense of absolute privilege, and D the defense of fair comment. Question 11. What needs to be proved by a customer who accuses a business of the tort of deceit? Answer. To prove deceit, it is necessary to prove the defendant knew the statement was false or acted recklessly and without regard to the truth, that the defendant intended to mislead the plaintiff, and that the plaintiff suffered a loss as a result of reliance on that statement. Question 12. Under tort law, a reasonable person is defined as. Answer. A reasonable person is someone of average intelligence who will prudently exercise reasonable care considering all of the circumstances. Thus, the standard considers the situation. The law does not require a person to take all possible precautions, only those that are affordable.